Welcome. This week we're beginning our transition away from the key submissions that we've spent so much time on, looking at some smaller submissions here, standard of identity, looking at the citizen petition process and how that relates to the standard of identity, in addition to where else we see the citizen petition used. And we'll continue next week looking at labeling, and we'll round out the course in the final week by looking at facility registration, looking at some of the smaller submissions that are less utilized but still available, and that will round out our course. So we've talked a little bit about standard of identity, especially at the beginning of the course, and in particular with the Intro to Food Law topic and looking at economic adulteration and talking about how this was born out of the distinctive names fiasco, how before in the 1906 Act, if you had a distinctive name, then you didn't necessarily have to comply with the economic adulteration provisions. 1938 Act gave us the standard of identity concept and created a number of standard identities at that time. And so basically the framework now that we have, if we have a product, is we can either comply with an existing SOI, we can look at it in the regulations, follow it for ingredients, amount of ingredients, labeling claims, a whole host of restrictions and directions that we have to follow. If we don't like those, we can go through a process that we'll talk about to amend the SOI. There's one particular example that we have in our readings looking at milk and nutritive and artificial sweeteners. If we don't have a standard of identity and we want to create one, there's a process to go through that, very similar to the amending the SOI, looking at some different criteria. And we have a great example, a current example of Sabra with the hummus that we had in our title slide, seeking to get a definition, a standard of identity in the regulations for hummus. If we don't want to go through that process, we don't want to do the submission, we don't want to have to make that process happen, then we can just comply with the common name, whatever is the common or usual name for that product, and label all of the ingredients by their common or usual name, and that will also comply with the regulations. So now everything is going to be regulated by a standard of identity, and you can go through the process to create it, or you can just stick to the common or usual name. For our purposes, of course, we're going to look at the submission and look at how we take the process to get a standard of identity petition. Even though the statute creates the framework for this, there isn't a statutory model, a statutory process that outlines how to create a new standard of identity. Everything is put into the regulations, and in 21 CFR 102.19 we see the petition for a common name. We can just go ahead and not have to actually petition for a standard of identity that restricts the ingredients and labeling and the like, but we can just go ahead and petition that we want to use this particular common or usual name and stick to that process. 21 CFR 130.5, we can petition for a new SOI. We can also amend an SOI. The process doesn't go through a particular form. It doesn't go through its own process. It follows the generic citizens petition, which is in 21 CFR 10.30. Citizens petition applies across the FDA. All product centers utilize the citizens petition. So we're not doing something that's statutory specific, food specific in any way. We're following the criteria from 21 CFR 130.5, which is very little, we'll see, and we're looking at the model for how to make that known to the FDA using the citizen petition. This is overall similar to the food additive petitions, the additive petitions that we've had for color and food, added substances, but there's less criteria, there's less structure. We don't have a specific amendment for standard of identity, so it's much less rigorous. It's a very similar process that once we actually get through the quagmire of what a citizen petition is, and we'll talk about some of the pros, the cons of how that process looks. But once we get there and we get to approval, we are added to the standard of identity part of the CFR. We're given a regulation, we're given a final rule. And of course, once we see that promulgation of a regulation, our minds should begin to think about all of those risks that we've talked about. In the additive process, we saw that when you have something promulgated and open to public comment, that there can be objections and hearings, and that can slow the process down, and it can maybe create some doubt on its future. All of that is in play here. So we'll look at the SOI criteria first, and then we'll look at the citizen petition criteria, how that generally looks, and then we'll take a second to look at a case study. Now, so far what we've been talking about is safety. Gross looked at safety, additive petitions looked at safety. We wanted to make sure that an added substance was safe for consumption. Standard of identity, as we alluded to and talked about, has not had that as a concern. The concern was economic adulteration. We were worried that people were being ripped off. That was the concern that Congress had when it passed the SOI framework in the statute, and that's been the overarching concern ever since. And so here we're not looking at safety, we're looking at protecting people's purse. We're looking at protecting people from economic harm. And so it's not surprising to see that the SOI criteria is very generic and focused on honesty and fairness. It wants to make sure that this food standard that's going to be out there is going to make very clear to people what the food product is and what its ingredients are. The only other element that we have to provide in requesting an SOI is substantiation. And we'll talk about that after we get to the next slide, which was the general citizen petition. What does substantiation mean? And I provided this Sabra petition that's 19 pages, very short, and you see right off on page 2 or 3, they referenced subsection C, and they talk about that in the footnote, that they're ready in a hearing to substantiate their petition and their basis for having a standard of identity for hummus that is exactly as they outlined, chickpeas and the other ingredients that they have. So we'll talk about that some more in a minute. But first, let's just look at the generic citizen petition criteria. Very loose format. It basically just asks that you have the action requested. Are you asking for a new regulation, an exemption from a current one, a revocation of a current regulation? Those are the actions that can be requested. What are the legal grounds? What is the basis for that? Is an environmental impact required? And a simple certification statement that follows the language in the statute. All of this is provided pro forma in the statute, in the CFR. And you just take the CFR section and fill in the blanks and start filling in each section, each header. Also in 1030, we see that there is a 180-day review time. And the FDA is required by the regulation, its own regulation, to provide a response in 180 days, either reject, accept, so on. But as we'll talk about in the pros and cons of this particular model, this vehicle for getting the FDA's attention, 180 days is rarely met. It's on occasion met, but very rarely. There have been GAO reports, Government Accountability Office, and Office of the Inspector for the Department of Health and Human Services that have looked at the citizen petition process, remembering that it applies not only to food, but important areas like drugs, medical devices, and found that citizen petitions can go on for 8 years and sometimes decades and not have any action taken. The FDA is working to make that better, but we'll talk about in the pros and cons why that may or may not happen. So we saw in the substantiation was a component when we looked at the criteria specifically for a standard of identity. And substantiation can have a number of elements. We look at claims. We always talk about substantiation. How do we substantiate that the claim is factual? Here, we're going to again be colored by this background. We're looking at whether or not a consumer can honestly interpret the name, the identity, and is getting what they expect based on that name. So if you tell me it's chocolate pudding in the name, and then it contains ingredients like avocado and vanilla, you're not dealing with me honestly. And so you're not going to be granted a standard of identity for a name and with ingredients that don't match. And that's more or less a simplified version of what's happening. To get into a more nuanced or debatable area, we can look at the milk and dairy SOI. Milk and dairy products have had standard of identities. They were among the first to have a standard of identity promulgated following the 1938 Act. So what we have now with the current petition, and it's some trade groups that are doing it, is a change from the existing SOI to a new one, to amend it to allow some new ingredients that aren't there and some labeling that isn't there. And we saw that in the readings. And what basically we have in the request is to use replace nutritive sweeteners, something like sugar, with non-nutritive sweeteners, something like aspartame. There's some other examples. And we've talked about aspartame a good bit in this course, and as you probably expect by this point, anytime the name appears, it's going to generate attention. And so one of the questions that the FDA has had is when you, under the current regulations, under the existing SOI, if you change the ingredients that's allowed in the SOI, then you have to put in a very conspicuous statement saying that it's reduced in calories or some other statement to that effect, and then list specifically in the common or usual name the sweetener that's used. And so that way the consumers can distinguish when they look at the milk counter that they have chocolate milk, and this is the most common example is the flavored milks that we have. You have chocolate milk, and then you have chocolate milk with reduced calories. Reduced calories triggers to the consumer a comparison, an idea to go ahead and look at the back of the panel and say, well, why is it reduced calories? What did they take in to make it reduced calories? What did they take out? And look at the ingredient package. Under the current proposal, they want to be able to add, the trade groups want to be able to add non-nutritive sweeteners, which could include aspartame, and not declare on the front of the package that it's reduced calories or that it's in any way different than other flavored milks. And I think the total is 17 other dairy products that they want to make similar changes to. And this is up to substantiation now. They followed all of the steps needed to do an SOI petition. All of that has been successful. But the FDA has taken the steps not only to request comment, but actually to post a consumer update on their website inviting consumer feedback and consumer indications about whether or not they'd be confused by the changes. And of course, with aspartame and artificial sweeteners on the slate here and labeling for those, the question has been among a number of consumer groups whether or not this is fair or accurate, whether or not this is something that complies with the substantiation and the general criteria for the SOI. So now it's going to be back on the petitioners, back on those trade groups that are attempting to gain this new SOI to come back with arguments, persuasive arguments that show why this should be allowed, why this isn't consumer confusion, or why having that disclaimer on the label is burdensome or in some way not needed for the new SOI. And so that's what we mean by substantiation, is that when there's a risk of consumer confusion, you're going to have to come back and respond to comments from the federal notice, from the Federal Register, comments from the FDA about why these concerns about confusion are, or how these can be corrected, or how they're not really supported. And so that's what we mean by substantiation. It doesn't occur too often, but you get into any of these controversial issues and there's a risk of that, and it can make the process definitely longer than what it can traditionally be. So it'll be interesting. I don't think that the hummus SOI will generate as much attention. Most of the ingredients, I think actually all of the ingredients they are using are whole ingredients, and their aim is really to have fairness in the market. They want to make sure everyone that's selling hummus is following what they view as the traditional food of hummus. And so I don't think that will generate the same attention as this amendment to an SOI that we're looking at with milk products, milk and dairy products. So generally what we can expect, 180 days, kind of, probably longer. What will be the response to the citizen petition is either an approved Federal Register notice or a denial explaining why it's denied. The other option is a tentative response where the agency says we need more information, we need more testing, we need more public comment. There can be a number of things that they want to get more information about. And then once we get to the approval part, then this substantiation hearing can be a component. There can be other hearings because it's going to be open to public comment. It could potentially be open to public hearings. And so that risk of what kind of happens at that stage is definitely present. This is overall the expected process. It's not necessarily the consistent, the uniform, the always going to happen process. And we'll talk about that next. Citizen petitions are not used fairly often. The FDA estimates that they get around 200 a year. It used to be lower. It used to be about 96 or 100 a year. There's been a little bit of a spike because there's a use of these for generic drugs and how you can get the status of generic human drugs versus protected patented drugs. So there's been a little bit of spike due to that. But on the food side, really not seen that often. Pretty unpopular, and unpopular for a number of reasons. Not a priority for the agency, so petitions can languish and they can sit out for a long time. And not popular among trade groups. You'll see some trade groups make the petitions, but by and large you see consumer groups and consumers which fit sort of the name, the citizen petition. So not a high priority for the agency, and not a priority because it's not part of a statutory framework. It's part of an agency efficiency, agency management regulation. It's a way for the agency to have issues brought to their attention that don't have an otherwise channel to get to them. So it's not someone's full-time job to manage citizen petition in each product center. It's part of their job, and amongst other more pressing matters, enforcement, pre-market, food additive petitions, other things that take priority. So one of the reasons that those can last so long, it's very problem oriented. It's usually there for citizens to raise issues. It's very common for citizens and citizen groups to use the citizen petition to raise questions about a particular product's GRAS status. I believe if there was even a citizen petition on trans fats before the agency determined to revoke that status. And so very interesting to look at. It's also used for an exemption. If there's a particular regulation or a particular enforcement action that's occurring, the citizen petition can be used for that with some success. So it's not usually there in a pre-market stance that we're in looking at submissions. It's usually there in a problem-oriented fashion, and so it's not usually high on the radar for industry to use. It's also unstructured. We saw the expected process, that how it should work, but other than the criteria that we see in 1030, there is no internal process that really uniformly manages how this works. And so the GAO reports have looked at it and said that, depending on the product center, you can go in and there's internal memorandums that are used to determine a product's status or a citizen petition status. And then what happens with those internal memorandums isn't clear. Does it then go to a director? Does it then go to a particular center director? How does that work? And so the GAO found that a lot of times these just get stuck because they're not really sure where to take them. And so even though there's supposed to be 180-day approval or communication, that isn't happening. And so they last a very long time. With standards of identity, it's a little bit more clear. So those typically don't get hung up as long, but they're not as fast either. So that's one of the reasons that they lose their popularity. So there's some pros, there's some cons, and unfortunately for standard of identity, it's the only way to go through the process. And so if it's, it's not a high priority for the facility either, because ultimately you're aiming at gaining better market share, or you're aimed at getting better fairness with your competitors. There are other things you can do to remedy that versus safety, which needs an immediate reaction. So for standard of identity, if that's what you ultimately want to do, this is just sort of the framework we have to live with. If there's another option that you have besides the citizen petition, and we'll talk about some of the other uses, it may be better to go through another route than to do the citizen petition. So since we're talking about the submission, it's good to look at what else we use it for. And as I mentioned, used for issuing a regulation, revoking a regulation, and gaining an exemption from one. You see it often used for revising or exempting labeling requirements. It's a very popular petition for GMO labeling, which currently is not required. All natural labeling, evaporated cane juice. There's a number of places where labeling is typically labeling disclosures that aren't required. Citizen groups seek to have a labeling regulation promulgated. There can be other labeling requirements that particular facilities want relief from. As I mentioned with GRAS, very popular for consumer groups. Also enforcement, response to enforcement action, seeking exemption. We haven't talked a great deal about dietary supplements, which of course are regulated as foods. There's a particular parts of CFR Part 111 which relate to good manufacturing practices for dietary supplements, where regulations apply, GMPs apply, but there is an exemption, and if you want the exemption, you have to go through the citizen petition. There's in particular about identity, 100% identity requirements for dietary ingredients. There's an exemption to that requirement, but you have to go through the citizen petition, which again has all the pros and cons that we talked about. New dietary ingredients, we talked about a little bit when we did GROS, saying that there is this similar criteria where if you meet these exemptions, then you don't have to do a new dietary ingredient application, but if you fail to meet these that are very similar to GROS, then you have to do the NDI. And so for the same reasons that GROS is very popular with consumer groups and in particular trying to revoke GROS status, there are a number of citizen petitions that attempt to revoke this exemption status for dietary ingredients that they argue should go through the new dietary ingredient approval process. So a number of uses that are out there. All of these are ad hoc, not necessarily statutory based or loosely statutory based, and that's why they go through this petition process that is generic and fits where there isn't a formal process. So it's required for a standard of identity. If you can make that analysis of whether you need to go through it or whether you mind going through a longer process, then you know what the process is and what the steps are to do it, and then just set the expectations that it may take some time. And so I'd encourage you to look at the milk industry's petition for an amended SOI and look at, as we did in the reading, at the hummus petition. That gives you a very good sense of what these look like. Very brief submissions, but still go through this process. So that's where we'll wrap up with standard of identity, and next week we will take off with some labeling discussions, labeling submissions that are required, and then in the last week we will touch on registration and a few of the more novel submissions that we have.